Actually ironic, going through what the California Supreme Court has done in the last 12 months, because I believe this case, its most recent employment law case, is likely to be found invalid under the AT&T mobility case. The case is called Sonic Calabasas versus Moreno. And in this case, the employer had, coincidentally, an arbitration agreement. And the arbitration agreement said you had to arbitrate all claims without exception. The employee wanted to bring a claim for vacation and overtime pay to the Labor Commission, the Division of Labor Standards Enforcement. And the employer said you can't do that. You must bring all claims to arbitration. You cannot bring any claims to the Labor Commission. The California Supreme Court said that is unconscionable. Ironically, and that case came out on February 24th, 2011, and the Supreme Court said there is a public policy in California favoring the rights of employees to bring claims to the Labor Commission that fall within the Labor Commission's jurisdiction. So the arbitration agreement will not apply to an employee's efforts to go to the Labor Commission first, and then appeals from the Labor Commission that would normally go to court, they can go to arbitration, said the Supreme Court. Now it's funny, so this case, Sonic Calabasas, sounded incredibly interesting when it first came out in February, and now April 27th, U.S. Supreme Court says what? Any state law that stands as an obstacle to the full enforcement of an arbitration agreement is void. So the U.S. Supreme Court found that the Discover Bank decision of the Supreme Court of California was void and preempted, and I believe this case is vulnerable too. The employer's attorney who lost this case before the Supreme Court has already reached out to one of the groups I'm a member of, the Human Race, by the way, and said he's going to ask the U.S. Supreme Court to take this case up. And I think it's very possible that the U.S. Supreme Court will accept the case for review in light of the AT&T case. So this may actually be the case that proves the point that the AT&T case, which was in the commercial context, will apply to the employment context too. So pay attention to it. Sonic Calabasas. Calabasas is a place up in 405. You've probably been in 405. Do you ever leave San Diego? The next California Supreme Court case